You want to know the quickest way to lose your lawsuit at trial? Come join me as I share with you this terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The quickest way to lose your lawsuit at trial is to lie, and then have your lie exposed during cross-examination. That is the quickest way for you to lose your lawsuit. Now, why do I say that? I say that because your credibility is everything when you bring a lawsuit. Your believability. If you lose credibility by telling a little white lie, if you lose credibility by telling a big whopper of a lie, guess what? Now there's a disconnect between your claim and what the jury is going to believe. The jury may no longer believe you. And in that instance, there's a very good likelihood you will lose your case and get thrown out of court without you ever seeing a single dime. That's the quickest way to lose your lawsuit. So how do you prevent this from happening? Simple. Don't lie. It's as simple as that. Now, you may not remember something, and now you may say something inadvertently that's a mistake. That's understandable. Not everybody is expected to remember every single detail of every single incident. And just because you remember one thing now and you remembered something a little different before, doesn't mean you're lying. It means you don't have the memory or you don't recollect what you said earlier. But what if you intentionally lie? What if you tried to hide something that happened in your past? Let's say you did something really stupid and now it was illegal what you did. You were arrested and you were convicted or you pled guilty. And now during the course of your medical malpractice lawsuit, the defense lawyer during pretrial questioning, known as a deposition, which is really a question and answer session that's given under oath. The defense lawyer says, hey, have you ever been convicted of a crime? And you, in knee-jerk reaction, immediately respond, say, no, never. And now you begin to think, wait a second. You remember a number of years ago, you were in fact convicted of a crime, or you pled guilty to a crime. Is that what he's talking about? Do you really have to answer affirmatively and say yes to that? But that has nothing to do whatsoever with your particular claim against your doctor. So what happens if you don't say anything? What happens if you don't ask your attorney about that issue and try and correct it a little bit later on? I'll tell you what happens. The defense is going to do research on you. The defense is going to do a background check on you. And believe me, they will find your criminal background. And now, once they see that you denied ever being convicted, now you've got a big problem. You've got a credibility problem. Because guess what? The defense lawyer isn't going to come up to you and your attorney before trial and says, hey, guess what? I'm going to screw you over at trial and I'm going to expose your lie in front of the jury. So if you want to resolve this case now, you better do it now. No. That's not how it works. The defense lawyer is going to ambush you at trial with that information. In all likelihood, you have not told your attorney about your conviction in the past and that you did hard time or that you were in jail or suffered some other penalty, right? And now you've got a problem. But you don't even realize you have a problem yet. The only time you're going to realize you have the problem is when you are up on the witness stand, a jury is sitting listening to your testimony, the defense lawyer has now gotten up to begin cross-examining you. And now remember, cross-examination is a search for the truth. And now the defense attorney has the goods. He's now going to tear you apart and you don't even see it coming. Hey, Mr. Jones, have you ever been convicted of a crime? He asks you in front of the jury, in front of a packed courtroom. And you say, no, of course not. And he says, hey, Mr. Jones, when you and I met a year ago, when I got to ask you some questions during your pretrial question and answer session, I asked you that same exact question. Isn't that true? Yes, you did. And you gave that same exact answer. Isn't that true? You said, absolutely not. You were never convicted of a crime. Isn't that true? Yes. All right. Your Honor, I have this piece of paper I would like admitted into evidence, and I would like the court to take judicial notice that this is an official document from the Department of Corrections of the City of New York. And the judge says, hand it to your opponent. And he gives a copy to your lawyer. So now the judge reads it over. He looks up, and then he looks over at the plaintiff's attorney, your lawyer, and he says, counselors, approach. Now, what does he see? He sees that you were, in fact, convicted of a crime. And now he turns to the plaintiff's attorney and says, did you know about this? And your attorney says, no, judge, it's the first I hear of it. All right, counselors, step back. Now, defense lawyer, continue your questioning. The court will take judicial notice of the contents of what's contained in this official document. Now, what does that mean? It means the court recognizes that this is in fact an official document from the Department of Corrections showing that you had a prior conviction and you went to jail for a certain number of years. Now he's giving the defense lawyer an opportunity to go after you because this is an appropriate line of questioning. Now the defense lawyer is told he can go ahead and continue questioning you along these lines. Hey, Mr. Jones, isn't it true that 3 years ago on July 1st, you were arrested? You were arrested for committing this felony act? Objection, Judge, your attorney yells. Objection overruled, meaning the question is proper, the witness is to answer it. And now he's stuck. Well, I don't remember that. You say, really? You don't remember? Well, how about 6 months later, you went to trial in this very county, in this very courthouse, and you were found guilty by a jury of your peers. Do you remember that? And now his face is bright red. Your face is bright red. And now you've got a problem. But now you've lied. And now you've created a bigger problem. The better result would have been, hey, listen, yes, I was convicted of a crime. Yes, I did my time. But this case has nothing to do with what happened then. Yes, I admit it. Okay, let's move on. That would have been the appropriate thing to do. But instead, you tried to hide it. And by hiding it, now you have destroyed your credibility. And I'm just using this as an example because the defense would spend a great amount of time destroying you piece by piece to show to the jury that your testimony is not believable, that you are not believable, that you are no longer credible. And at the very end of the trial, the judge tells the jury a specific section of law that has to do with credibility. And he tells them, ladies and gentlemen, if you find that a witness has testified falsely about one thing, you have the right to disregard all of their testimony. Imagine that. All of their testimony. Not just some of it, not just part of it, but all of it. And it doesn't matter whether you tell a little white lie or tell a big whopper of a lie. The end result is the same. Your credibility is gone. So the quickest way to lose your case is to lie, and to then have that lie exposed during cross-examination. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did in fact happen here in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day.